Good morning. This is State Representative Jim Durkin, House Republican leader of the 82nd District, Western Springs, Illinois. For over a year now, we have been bringing to light the horrible aspects of Governor Pritzker and the Democrats' anti-law enforcement, anti-crime victim bill, what they wrongly call the SAFE-T Act. In that time, we have pointed out all the new laws' horrific shortcomings that has created a consequence-free Illinois for criminals. We have pointed out how hardened violent criminals, offenders that have already been given second and third chances, are given more rights than victims of crime. We've talked about the massive amount of police who are leaving the force because this law attacks their career instead of going after people who attack the laws of Illinois. In 2021 alone, almost 900 officers in the state of Illinois left their respective departments. 717 retired, and 176 others either resigned or transferred to other police agencies outside the state of Illinois. And that's according to the latest figures we have. And that will continue. I talk to police on a regular basis. It is no longer worth them doing their jobs as opposed to working under these conditions. We talked about giving criminals the right to demand their victims the ability to attend hearings and numerous unmonitored phone calls from a criminal that they will have to be able to make those phone calls to witnesses for intimidation and tampering with evidence. The delusional demagogues of the defund police movement have repeatedly denied our claims to try to hide the truth while at the same time praising themselves for this work and saying, job well done. We all know how hollow their words are when we see the actions that take place in the streets of Illinois. Most everyone in the state, besides the Democrats who passed this law, knew there were going to be horrific real world consequences created by these poorly thought out changes. People will be hurt, and now we are seeing it firsthand. Today, we're here to talk about what will be the first of many cases where violent criminals and known gun offenders will not be held responsible for their actions. This past December 18th of last year, a 54-year-old woman, an innocent bystander, was struck and killed in a shootout on the 4900 block of West Gladys in Chicago on the west side. This innocent bystander was killed when two men got into an argument during a drug deal about the price of drugs being sold. Now, how many times have we seen that play out in the streets of Chicago and other metropolitan areas in the state of Illinois? If it happened once, it happens 1,000 times. After the argument, Travis Andrews, who was the drug buyer, went to get a gun. And on his own admission to investigators, he said he saw someone standing down the block. He could not see who it was, but he decided to fire 2 shots in that person's direction. He just decided to open fire on the streets of Chicago, not knowing who he was shooting at, but pulled the trigger anyway. The person he was shooting at fired back, killing this innocent bystander, the female victim. Andrews identified himself to investigators in the surveillance video, and we also know that he has prior convictions for aggravated battery, robbery, several misdemeanors, according to the Cook County State's Attorney. He also has repeatedly failed to show up in court hearings for his previous cases. But yet, under the new law of Illinois, the so-called SAFE-T Act, he is not going to be charged with first-degree murder. As a matter of fact, a grand jury returned a no true bill, stating that he could not be specifically charged because of the new law that went into place that changes the rules for felony murder. Now in Illinois, defendants are no longer responsible for the decisions that result from their actions or reactions, specifically when it comes to violent crimes. Instead, he's charged with a weapons violation, a class 3 misdemeanor, which is probationable. That's right, a man who admitted to being there, admitted to starting a shootout after a drug deal went bad, a shootout that ended in murder, a man with priors and the inability to make his court dates, but he was not charged in the death of this innocent victim on her way to buy lottery tickets. The woman died. She was murdered in the streets of Chicago. Yet Democrats think the person who started the gunfire only committed a weapons violation. This scenario will assuredly play out over and over again. Bad drug deals, gang conflicts with bullets flying, hitting unintended victims like we see here, or what we often see on a daily basis, where children playing in the park or their front yards are shot because of a gang rivalry, a gang shootout in which they are unfortunately and sadly the victims. Illinois has become a nearly lawless state when it comes to crime. We see offender after offender freed while awaiting trial on violent crimes, specifically in Cook County. We see headlines yesterday, every day, of shootings, killings, violent attacks on retailers, and yet the Democrats keep denying that there is a problem. We have a governor, J.B. Pritzker, who is more concerned about masking children than unmasking criminals. Just last week, Governor Pritzker shouted down legislators who oppose his pro-criminal approach. He even said that we are not characterizing the bill properly, and we're part of the old lock 'em up gang. And he said that, how can we talk about that when many of these provisions have not gone into effect? Well, how does he explain this dismal failure that played out before the Cook County grand jury on this investigation, where murder charges were rejected because of the change in the law that the governor signed? Now, on background, I'd like to tell you that I am a former prosecutor out of Cook County, but also I think the governor needs to know that just this past year, I was awarded, one of 3 people awarded the Illinois Innocence Project Award for my work done with juvenile interrogations, because I do believe in second chances. I also believe in fair play. I know that people can turn their lives around, but also being a former prosecutor, I know that many people never will. There will always be a time, and they will always have a life of crime, especially when there are no repercussions and when crime actually pays. We need to immediately repeal the failed Democrat law, the Safety Act, before more tragedies occur. The Safeties Act name is a fallacy. It isn't working. No one is safe today. We've got to be better than this business as usual, the nothing to see here approach by the Democrats. We need to repeal the law because it isn't working. And we must rebuild our criminal justice system so people can feel safe in Illinois, knowing that criminals do not get a free pass. Thank you.
I'm State Representative Dan Ugasti of the 65th District. This includes portions of Kane and McHenry counties. The tragic murder of an innocent bystander, the Cook County grand jury's decision not to indict shooter Travis Andrews on first-degree murder because of the Safety Act highlights what we have been saying all along. The Safety Act has made Illinois a less safe place to live. This rushed law is going to let a murderer get off easy. It doesn't matter that the woman whose life was cut short was not Andrew's intended victim. He got a gun to kill someone over a perceived slight in a bag of weed, and her life was stolen from her. Even so, the Democrats insist on staying the course with the Safety Act. They refuse to acknowledge that the policies they passed are leading to spikes in crime and instances like this, innocent lives being lost. There are examples of them outright rebuking our calls for repeal. Our caucus has filed legislation to repeal the Safety Act that my colleagues and I are proudly sponsoring. Something needs to be done to address violent crime in Illinois, but it is clear that rushing legislation through the General Assembly was not the right solution. We need more Democrats to come forward and join us and say, let's change course before more dangerous people get off easy and are back out on the streets after committing serious crimes. Let's change course before more people die. We stand ready to work with the Democrats and craft legislation that will protect our communities and reform our criminal justice system. Work with us. We'll now hear from Patrick Windhorst, one of my colleagues from the 118th District.
Thank you, Dan. I'm State Representative Patrick Windhorst of the 118th District, I represent all or parts of the southernmost 11 counties. Before being elected to the Illinois House, I served for 14 years as a Massac County State's Attorney. I've prosecuted criminal cases of all kinds, including felony murder, and I've worked directly with police officers and sheriff's deputies to build cases and put dangerous people behind bars. In January of 2021, Illinois House and Senate Democrats dropped a sweeping amendment on legislators in the middle of the night during a lame duck session of the General Assembly over the objections of Republicans and police advocates like the Illinois Sheriff's Association and the Illinois Association of Chiefs of Police, and tens of thousands of Illinoisans who filed witness slips against their reckless and poorly drafted criminal justice reform package. I was one of only 2 Republican legislators who Democrats allowed to ask questions of the Safety Act sponsor before they shut off debate on the bill. Governor Pritzker signed this law. Now we're seeing the impacts of this action. On the only in-person session day this year, I led a press conference at the Capitol to announce the filing of a resolution, House Resolution 598, calling for the repeal of the Safety Act. On January 20th, just 19 days ago, I led another press conference detailing legislation I have filed, House Bill 4499, that would accomplish that goal. Here is a brief history of the spike in crime that has transpired in the months after Governor Pritzker signed the Safety Act into law. In 2021, 76 Chicago police officers were shot or shot at. Murders reached a 30-year high in the city. Chicago saw 1,800 carjackings last year. That number is higher than any other large city, including New York and Los Angeles. Organized smash and grab robberies totaled millions in lost revenue for businesses and terrorized average citizens and business owners in the city and the suburbs. Citing COVID-19, Governor Pritzker has let thousands of inmates out of prison, including murderers and rapists. People of our state deserve safety and the knowledge that criminals will be held accountable for their actions. Now, in a real-world test of the Safety Act law rewrite of the felony murder statute, a grand jury did not indict a man who allegedly started a gunfight which resulted in the shooting death of a woman. In response to the decision of the grand jury, Cook County State's Attorney Kim Fox's deputy said there were no indictments returned for the murder charge based on that change in the law. Now, there is no ambiguity in that statement. This is a direct correlation to the Safety Act's changes and what a grand jury decided to do with a violent offender. Think about that. Seemingly every day, there is a new case that illustrates how the Safety Act's provisions have harmed public safety and the pursuit of justice. As additional parts of the Safety Act eventually take effect, especially the elimination of cash bail for dangerous offenders, our public safety will only get worse. Perhaps now, with the grand jury unable to indict someone for murder whose actions led to a shooting death and citing the Safety Act as their reasoning, maybe our friends on the other side of the aisle will heed our call. For the safety of all Illinoisans, the so-called Safety Act must be repealed. Now we'll open it up for questions.
The first question we have is for Leader Durkin. You have been talking about this bill for over a year. Have you personally met with Governor Pritzker to voice your concerns or just done it through press?
Well, I've spoken publicly over the past year about the consequences that we will face in Illinois when this law and different portions of it go into effect. But I did meet personally with the governor in beginning of last year after it had been passed out of both chambers before he signed it into law. And I specifically went section through section of the bill with him to talk about the ambiguities, the inoperable sections of that bill, but also clearly the anti-police and anti-victim provisions of that bill that are not going to be good for the ultimate responsibility of the state, and that's to protect our citizens. But I did specifically talk to him. He had no response. I did my best.
All right, our next question comes from Dave Dahl. We got several that are kind of similar, so we're going to go with Dave's. Thanks. Off topic. Have you been briefed on today's speech by the governor, and what do you think of Illinois' endgame on masks?
Let me start first and let my other colleagues go. Briefed, no, but this is the typical approach of the governor over the past 2 years. He's excluded Republicans from any type of dialogue on major issues. He has not invited Republicans to participate in any meaningful discussion, whether it's in a closed meeting of leaders, but also on the floor of the House of Representatives and chambers. The governor has taken this go it alone approach too long. So I don't know what he plans to say today, but I hope that he does what other Democratic governors throughout the nation are doing, saying that the masks are done. Let's get back to business as usual. Let's let business operators finally get back to work. Let's let parents and children go back to schools without having to deal with this mask situation. So I hope he says that we are done with wearing masks in not only in the public arena, but also within our retailers and also in the private areas that he has restricted people over the past 2 years. But it's really important to know the governor has not briefed me. He has not briefed anybody in the Republican caucus. But this is a man who said last week that if you challenge me, you will never be in his state of the state speech. If you're going to challenge me, you don't have a place at the table. Well, Governor, I'm going to continue to challenge you. And that's my responsibility and my job. And it's also the same responsibility for members of the Democrat side of the aisle as well.
Right. And we have a follow-up to that from Greg Bishop. Why should the legislature be more involved in these decisions?
Pat or Dan?
I'd be happy to jump in on that. The legislature should have been involved since the first 30 days expired. And I filed a bill back in May of 2020 and another one in 2021 that would insist that the governor only be allowed to declare a state of emergency for 30 days. And after that, the legislature must become involved. It's HB 843 is the current version. And I believe that the governor, as well as the Democrats, need to consider it. We need to pass it going forward because no one should act alone for this long, deciding the fate and what happens for the people of the state of Illinois.
All right, our next question comes from Craig Delamore. Are there no provisions of Safety Act worth keeping? Why not just repeal the felony murder provision?
I'll let Pat start with that and I'll add a few things after that.
Yes, there are some provisions of the act that are worth keeping, particularly those that have increased compensation to crime victims, which was important. And in fact, in my repeal legislation, those provisions would stay in place. But what we have to remember is the way this bill came about. We go back to January of last year. You had two large pieces of legislation which were shoved together to make one overall omnibus bill. There was no Republican input, no public input, and very little input from law enforcement. We have been able to point to time and again errors in the bill, problems with the bill, inconsistencies in the bill. Our belief is the better approach with repeal the bill, come back, work through those issues, get public input, get law enforcement input, get input from our side, and craft a piece of legislation that will improve public safety and also reform the justice system.
We need to go further than just the repealing and reworking the felony murder portion of the bill. There's a few other ones that I'd like to just point out. Just recently, the Democrats tried to fix a problem with the 3 phone call rule, and we debated it on the floor. And it really didn't turn out to be 3 phone calls that a person who has been detained or someone who's in custody will be able to have to make a call to his attorney or a family member. The way it plays out, the way it's drafted, a person who is charged with a crime will have at least 9 phone calls, particularly in Chicago. When you're detained in a squad car, when you're brought to a district, you get 3 phone calls in the squad car. And if you're ultimately charged and you're in the Cook County Jail, you get another 3 phone calls. That's 9 phone calls. But the way the bill is drafted, it says that the only people that this person who has been charged can call is an attorney or a family member. It doesn't take into consideration that sometimes this person who's been charged has abused a wife, or they have abused a family member. That person will be able to call that person who's been the victim, that domestic violence victim, or that sexual assault victim, at least 9 times to be able to, with nothing other than the intention to intimidate and to keep that person from cooperating with law enforcement. That is a huge gap in the law, which I pointed out on the floor, but the governor seemed fit to sign it into law. And more importantly, for the first time, a defendant will be able to compel a victim to appear at a detention hearing, which is going to be the new bail hearing. I have no idea what, other than intimidation, of what that would be able to accomplish, but to drag a victim A woman who has been beaten close to death or a child who has been sexually assaulted could be compelled through the defendant to appear at a detention hearing. It's not a critical stage in this process. This is wrong. It completely is in violation and flies in the face of the constitutional amendment that the people of Illinois passed some 4 years ago, protecting the rights of victims who should be free from harassment and intimidation in the court process. That also I need to point out.
All right, I think that's our last question for today. If you have any questions we didn't get to or any follow-ups, please don't hesitate to reach out. Thanks for joining us.